just to support my colleagues' presentation, I wish to rely on the case of Odhiambo versus the Attorney General and two others, where the court pronounced itself that the court can intervene in matters victim protection to respect their rights and to safeguard their views. Yona, Section 9 of the Victim Protection Act guides this court to permit the views of a victim if the victim has been made sentiments in regard to them being processed through trial because of the complainant that she is comfortable to go through a virtual trial because of to give the views, and we wish to invite this court to consider these views. When you also look at Article 50(1) of the Constitution, every person has a right for his case to be resolved in a fair trial. Going down Article 50, sub-Article 9, that article states that Parliament shall enact legislation providing for the protection, rights and welfare of the victims. And that's why the Victim Protection Act came in, and it talks of all these presentations made before you are on behalf of the victim, and they emphasize that there is need for them to be taken through a fair trial. So we are making this application, let the concerns be adopted.
The list that my learned friends want to take court through this. If they are making their applications on the basis of the Victim Protection Act, and they're referring to Section 6, Section 7, Section 8, it's only to allow them to participate in the proceedings. We don't have a problem with that, and we are on record having requested their counsel for the victims to make that application so that the court can define the scope of the anticipation of the trial. However, Your Honor, that should not be the basis of the application they're making before the court. My learned friend appears with me in a civil matter, that is High Court Commercial Court number 23 of 2024. Between my client's company, another law firm, and they actually applied to be enjoined as interested party, and today as we speak, they are full parties defendants in that matter. Okay? So what they are talking about, the threat to her life, they have not given us any cogent evidence that there is such a threat. I'm hearing that from counsel. Would it not be better for him to take the stand, give the court cogent evidence on what he's saying about, what he's talking about? And in that case, it ceases being an advocate, he will be a witness. You know, the reason why you're being treated to this, which I didn't want to go into, is that on the 4th of April, actually on the 7th of January 2024, the so-called main witness left this country sneaking through the Lumumba International Airport, where...
You know, that will now give us the evidence.
No, I'm giving you, if you allow them to give you hearsay evidence, Your Honor, I'm also an officer. I'm equally an officer of the court.
Also, I've not said you're not an officer, most of what is my hand.
Yes.
You know, when we get into the main merits of the hearing, you've mentioned, you know why I'm not writing? I cannot rule anything, what is happening in the civil matter before the High Court. So that's why I'm not writing, because I'll just be adding, you know, pepper into, I'll be just putting pepper into pen. When you ask, okay, talk, speak.
It's becoming a little bit difficult to respond to these issues because you're saying you're not writing, they are made an
But
application.
what do you expect me to write about the High Court?
No, I'm giving you facts in response to the application.
Okay, so just
And if in good time, I'll be able to demonstrate to the court the relevance of the facts. If the court does not want to hear us on that, we'll keep quiet and we'll let the court proceed as it proceeds. It wants. We'll sit down.
okay, speak.
Yes.
Okay, can you please in and out counsel? Don't be emotional in matters about clients. They come in and they leave every other day. But why I will not write about the High Court? Because I have no jurisdiction. And when a court has no jurisdiction, you put down your pen. Whether you mention matters in High Court, there's nothing I can do about it. Because I don't even know. It is you tell me.
Allow me.
Kindly, go
Allow
ahead.
me. What we are saying is that my landed friend and me are appearing in a matter in which the client, my client, are appearing. What decision are you supposed to make on that matter? What conclusion are we asking you to draw on that? What orders are we asking you to draw on that? Nothing. We are giving you facts. Then we can build our application and respond to this matter. I've not asked you to interfere with that. I will have forgotten my law if I'm going to ask the court to intervene in a matter that is in the